Jake Paul is getting sued for defamation. I've got the complaint. Let's take a look. So just over a week ago, Jake Paul, in an interview with IFL TV, accused Matchroom Boxing, a rival boxing promoter, of corruption. He contended that Eddie Hearn and the owner of Matchroom Boxing had bought off Glenn Feldman, one of the judges who scored the Katie Taylor versus Amanda Serrano fight and the Alexander Usyk versus Anthony Joshua fight. So this has been in the media basically since it happened because Eddie Hearn took this a little bit personally and publicly called for a retraction and apology. Did not get that. And so now he has followed up with filing a lawsuit in the U.S. District Court for the Southern District of New York. So we're going to take a look at this complaint and just give you my initial reactions about it. Are these complaints meritorious? And are there any weaknesses here that Jake Paul is going to be able to exploit? So the complaint in many ways reads something like a promotional release for Matchroom Boxing. The basic facts underlying the cause of action are fairly straightforward, but they've taken some time to lay out things like how for decades Matchroom has worked tirelessly to build its reputation, that it has sought to treat others with fairness and dignity and within the guidelines of the boxing rules, and basically doing what they can to discount the presumed defense that Jake Paul is going to bring, which is that, look, this is just smack talk, okay? Corruption in boxing is nothing new. This has been going on probably for as long as boxing has been a commercial sport. Right now, as we speak, there is controversy over amateur boxing being scratched from the 2018 Olympics in retaliation, basically, for some bout corruption allegations from back in 2016. So this is a long-standing and very well-known problem in the sport of boxing. So it could be understood that Jake Paul might take the position that, look, this is a common problem. It's gone on for a long time. It's something that fans of boxing do and should care about. So I have the right and maybe even the responsibility to call it out when I think it's there. So Eddie Hearn in this complaint is doing what he can to get around that type of argument, to cast this as a baseless accusation, something that is unsubstantiated by any type of evidence. So the statements themselves are pretty strong and not necessarily that good for Jake Paul. So he's talking about first the Katie Taylor versus Amanda Serrano fight and what Jake Paul believes to be evidence of unfair scoring. He says, I still think Amanda Serrano won the fight. Then you see how this judge, Glenn Feldman, who had the biggest gap between Taylor and Serrano, everyone pretty much had it a draw, or that Amanda won. But there's this judge, Glenn Feldman, who scored it such a big gap for Taylor, gave rounds that Amanda clearly won to Taylor. So that's his characterization of the scoring. A little bit of a problem with that, though, when you go and look at the actual scorecards. Glenn Feldman scored the fight almost exactly the same as Guido Cavalieri did. The only difference is in round 5, where Amanda Serrano had Katie Taylor pretty hurt, pretty stunned. There was a moment there where it looked like she was going to put away the fight. And so Guido Cavalieri scored that a 10-8 round for Amanda Serrano. Glenn Feldman just scored it a 10-9 round. Katie didn't get knocked down. She did survive the round. So I can see an argument for either choice on that one. But otherwise, those scorecards are the same. And it was only Benoit Roussel, I'm not sure how you pronounce his name exactly, but he's the only one who scored the fight in favor of Amanda Serrano. So nobody scored this a draw. Nobody scored it close to a draw. This was just a split decision where two judges had almost identical reads on the fight, with the only difference being they swapped rounds 3 and 4. And then, like I said, round 5, Guido Cavalieri scored that a 10-8 round. So I gotta say, just looking at the scorecards there, I'm not sure this is the strongest argument to make for evidence of some kind of fix. But moving on, he then talks about the Usyk Joshua fight. He says, Glenn Feldman shows up in Saudi and scores Anthony Joshua to win the fight when everyone who watched the fight said it was not a split decision. Usyk had a runaway victory, clearly won the fight. This judge, Glenn Feldman, gives it to Anthony Joshua. It's like a repeated crime here. This type of shit, I'm going to call it out here in boxing because it's bullshit. Clearly, this guy is getting paid money by Matchroom Boxing. Well, I will say he's got a better argument here on this Usyk scorecard because, yeah, Glenn Feldman in that case was the judge who was way out of whack with how the other two judges saw the fight. But once again, I gotta say, this isn't the most unusual thing to ever see in boxing. If you watched this fight, again, no knockdowns. It largely has to do with what the judges are prioritizing as dominance in the round. So boxing is scored round by round. It's based on who is landing the more effective punches, who is controlling the pace and distance of the fight. And so this was another fight where, yes, I watched it, clearly saw an Usyk win, but it's not so overwhelmingly dominant that you can't see a lot of these rounds as potentially being swing rounds that could go either way. So again, in this situation, Glenn Feldman was the one who was out of whack. And so what Jake Paul is pointing to here is the fact that Matchroom Boxing represents Katie Taylor and Anthony Joshua. And so in his argument, he believes that they were the beneficiaries of these outlandish decisions in their favor that clearly indicate some type of match fixing by Matchroom Boxing. So what really stands out about these statements that Jake Paul made is that they really aren't qualified. And in that sense, probably a little bit imprudent to characterize them like this. He did not cast this as we should be wondering if there is corruption here, that it's a possibility that there's corruption here, or even, in my opinion, this smells like corruption, okay? He flat out makes the accusation. And so that's a problem. Defamation exists as a cause of action today It's existed for a long time in the common law, but you might remember we had a fairly extended period in our history where dueling was the norm. It was only after Alexander Hamilton got shot and killed in a duel by Aaron Burr that there was then a push to encourage people to go to court for defamation to get redress for the injury to your honor rather than going out with pistols at dawn. So this is fairly squarely the type of accusation that, yeah, goes to somebody's honor. I accuse you of fight fixing, of paying off a judge. That is the type of thing that I think you put yourself back in 1790 and yeah, you would see, I'm going to demand a retraction or I am going to throw the gauntlet. Looks pretty squarely within the type of statement that defamation is generally going to cover. So that doesn't look so good for Jake Paul. There's another thing that doesn't look so good for him either, which is that Matchroom and Eddie Hearn have alleged this is defamatory per se. And what that means is that most of the time in defamation, you have to prove that there was some type of injury you suffered as a result of the statement that was made. But certain types of statements are presumed to be inherently damaging. They're just so bad that everybody knows this is going to hurt your reputation. You're going to suffer from that. So you don't have to prove damages if you can establish it was defamatory per se. And New York recognizes defamation per se for statements that tend to impugn a business's integrity. So with a corruption allegation against a boxing promoter, I mean, again, especially in light of this context with boxing and the amount of corruption that we know about that goes on in it, yeah, this is the type of accusation that is going to make Matchroom Boxing, look like a dirty promoter, part of the problem rather than part of the solution. So it does look to me like, yeah, that's going to fall squarely within defamation per se, meaning Matchroom isn't going to have to prove I lost this bout, I couldn't put this fight together, I couldn't promote this fighter because of the impact of these statements made by Jake Paul. They're not going to have to do that. It's going to be presumed, and then the jury has a lot of leeway to decide what actual compensation is necessary to make you whole for that injury. So those things don't look good for Jake Paul in this complaint, but there are definitely some weaknesses here. And so let's go ahead and take a look at those. The first one, anytime you are dealing with defamation in the United States with public figures, you're going to have an actual malice hurdle that you have to clear. This is a substantial difference between U.S. defamation law and defamation in the UK, where Matchroom Boxing and Eddie Hearn are located. So you hope he's gotten good legal advice about exactly how hard it is to clear this bar in the United States. Because that is something he would not have to do were this suit happening in the High Court in London. So actual malice means he has to prove Jake Paul actually knew that what he was saying was false. Not just that he was careless in making the accusation, but that he deliberately said it knowing that it was false and basically with the intention of poisoning the atmosphere surrounding Matchroom Boxing. And that's pretty hard to do. In this complaint, one of the things that they have relied upon is an argument that the promoters don't pick the judges in the state of New York, where the Taylor versus Serrano fight happened. They're picked by the state boxing commission. And the argument is that Jake Paul, being a boxing promoter himself through MVP Promotions and the promoter of Amanda Serrano, he would know that. So he would know that Eddie Hearn didn't have the ability to pick the judge and therefore, set it up to pay him off. And that's a fairly decent argument about what he knows or should have known. But the problem is that knows or should have known is not the standard. It is actual knowledge that it's false. And so there's a couple of things that Jake Paul can potentially do here. One of them is the kind of fun old, well, I'm just too dumb to know that kind of defense. Hey, I'm new to boxing promotion. I'm not aware of all the ins and outs. I don't know if there's some backroom way that Eddie Hearn could arrange with the New York State Athletic Commission for Glenn Feldman to be one of the judges. I don't know. I didn't even know that. That is a possibility. We'll have to see if he pursues that. But even if he doesn't, I think he's still got a pretty good argument against actual malice. Just going back to the statement itself, he gives reasons for why he thinks Matchroom Boxing fixed these fights. We've already talked about why they may not be the best reasons in the world, especially if you're basing this off of the Taylor versus Serrano card. It's not that outrageous. But it doesn't necessarily have to be a good reason. It just has to be enough of a reason that it gives him a legitimate basis to believe, yeah, I think Eddie Hearn fixed this fight. So they're going to have to overcome the fact that he explained himself and at least provided some justification for this allegation that he's making. The burden of proof here is going to be on Eddie Hearn in Matchroom Boxing. And that's part of what makes it so challenging. They have to prove this negative that you didn't know. You knew it was untrue. You didn't have a good faith basis for believing it. And so the problem is, having laid out his basis for believing it, they're going to have to now go and show why that's not a good enough reason, or you didn't actually, believe these things. My critique of the Taylor versus Serrano scorecard argument, might help, but this one is just going to be a potentially tough one to overcome. So New York, like many states, although certainly not all, does have an anti-SLAPP statute. It's fairly new. They just expanded it in 2020 to make it more protective. And so it applies anytime there is an action involving public petition and participation. And they define that to mean any communication in a place open to the public or a public forum in connection with an issue of public interest. So that's what we got here. We got statements about high profile, boxing match, boxing promoters taking place on an interview that is published throughout the world. So it's going to fall within this anti-SLAPP statute. And so what New York's statute allows is for a couple of things. One, cost shifting. Normally in the US, you get sued, you're on your own, you're on the hook to pay for your defense. There's no automatic way to recover your costs or attorney fees, even if you win at the end of the day. So barring some type of contract or statute that gives you the right to do that, it can be very expensive to get sued in the United States. So New York provides for that cost shifting. Basically, what they're doing is saying, we don't want there being a bunch of frivolous lawsuits being filed by people who don't want to be criticized and use litigation as a tool to shut up their enemies. And so they provide for somebody who's been sued in a frivolous speech-based action to recover their attorney fees. The other thing it does is allows for a pretrial litigation over basically whether this case is going to be able to meet the requirements of a defamation claim. And so that actual malice requirement is often and is likely here going to be the linchpin for whether this case makes it to trial at all. The judge is going to be evaluating, is there evidence here that Jake Paul actually knew what he was saying was false and went ahead and said it anyway? And so that could be a close call. If he goes along with my reasoning, I think that's going to be a tough one to clear. But often judges will decide, we'll just let this thing go to the jury, and that could certainly be an outcome in this case as well. But there's a second problem with this lawsuit that, while it seems maybe small and technical, it actually looks pretty fatal to me. And that's having to do with, why are we even in New York for this complaint? Jake Paul, even according to these allegations, he doesn't live in New York. He lives apparently in Puerto Rico. The basis for them arguing that New York is an appropriate jurisdiction to hear this claim is the fact that with most valuable promotions, Jake Paul put on the Taylor versus Serrano fight in New York. But, you don't open yourself up to be sued anywhere in the country just because you've been there once or you did a transaction there one time. It's a little bit harder than that to drag somebody into a foreign jurisdiction to answer a lawsuit. So the New York statute that provides for personal jurisdiction here is fairly specific. It says, as to a cause of action arising from any of the acts enumerated in this section, a court may exercise personal jurisdiction over any non-domiciliary, meaning a non-resident, Jake Paul in this case, who transacts any business within the state or contracts anywhere to supply goods or services in the state. So this is basically what they're relying on. They're saying he put on the Amanda Serrano versus Katie Taylor fight in New York, therefore he's conducted business here. And these comments that he made to IFL TV have something to do with that fight and therefore arises from the fight. No, I don't see that at all. These are entirely separate actions that Jake Paul has taken. His choice to give this IFL TV interview, wherever that took place, did not arise from having engaged in business in the state of New York. It's a completely independent criticism. So, to me, this jurisdictional hook looks extremely weak, and it wouldn't surprise me at all if Jake Paul's first reaction to this complaint is going to be to file a limited appearance for purposes of challenging the jurisdiction of the New York court to hear this case. Now, that wouldn't necessarily make the entire issue go away. He can still be sued anywhere that does have jurisdiction. So if he lives in Puerto Rico, that's going to be an obvious potential forum for this lawsuit to take place. They could just go refile it there. When you're dealing with defamation that arises from something that is published over the internet, there's also all kinds of complicated rules that can come into play about where did that injury actually occur, what is a proper jurisdiction for being able to litigate that. So they might be able to get there. They might even be able to justify New York under some of this interstate jurisdiction law, but they haven't pleaded or alleged that so far. So, barring some pretty good argument that there's a reason why New York is the situs of this injury, I just don't see a very good chance that this complaint could survive an initial challenge to personal jurisdiction. So the bottom line, going through this lawsuit, yeah, I can see a pretty good argument on Matchroom Boxing's part that this is defamatory. It is defamatory per se. It is clearly an accusation, a j'accuse, not a statement of opinion or trash talk. But I do think there are some good points that Jake Paul is potentially going to be able to make here. I think the jurisdiction argument is potentially fatal, at least in this particular court. And I think the actual malice bar, as it is most of the time with these public figure defamation cases, it's going to be hard to clear. So I am going to be following it. If you're interested in this case, do stick around. And as things develop, I will keep you posted.